5 minutes behind the schedule, so I think that's still acceptable. After a successful day yesterday and the discussions, I think we will continue in the same tone, and besides, and as the continuation of yesterday's very exciting and interesting discussions, I think that what is going to follow is going to be as interesting and as good for discussion in the time that we have ahead. So, first of all, I would like to thank the organizers for bringing us all here to Belgrade. It's wonderful to be here once again. So, thank you. I would like to thank to the Institute and especially to Mr. Goran Basic for having us all here and for hosting us here in Belgrade. I'm really honored to be able to host this, to serve as the chair of this panel with three distinguished speakers, two of whom are the former presidents of the advisory committee and one current president of the advisory committee. So what we are going to hear today is quite interesting, and I've underlined some of the keywords from the overviews of their presentations. The first speaker is going to be Petra Roter from Faculty of Social Sciences from the University of Ljubljana and the current president of the advisory committee. And she's going to give us an overview of the context in which a framework convention has been implemented over the past quarter of the century. So quite a long time, but maybe not long enough. We will see. Then we will have the presentation from Professor Rainer Hoffmann from the Faculty of Law at the university and also former president of the advisory committee. And one of the key words in the overview of his presentation is critical analysis. That's what I've read, and I'm really looking forward to hear this critical analysis of the monitoring and the implementation of the Framework Convention in the period between 1998 and 2004. And finally, we will have the third presentation by Marie Hagsgaard from I guess I pronounced it acceptable. Is it acceptable pronunciation? Hagsgaard. Okay. Thank you so much. Weird. Weird letter A. Weird letter A. So she's the member of the Swedish Truth Commission for the Sami people and the former president of the advisory committee as well. And some of the key words from her presentation are the follow-up meetings, assisting states and representatives of national minorities to find practical measures to implement the Framework Convention. So starting from these three keywords, I would like to give the word to Petra Roter to present us with the main points of her presentation today. And what will follow will be the discussion, and pretty much we have an hour and 45 minutes for this panel. And then we will give 15 minutes break between this panel and the next one, which starts exactly at noon, at 12 o'clock. So Petra, please go ahead.
Thank you very much, and good morning to everyone. I'm not sure I'll be able to give an overview of the 25 years, but I was carefully also listening to what was discussed yesterday. So perhaps 3 points or 3 core issues I'd like to address. The first one is a little bit a reflection on the monitoring process itself. Then I'll end up with a few dilemmas that we are facing. And the third part, I really would like to sort of hear the feedback by colleagues, friends dealing with monitoring or sort of assessing the work of the advisory committee to see in a way how we can improve. Of course, I'm joined by 2 former presidents, and also Rainer is the only one in a long time that served on the committee for 10 years, because he was in the first batch of experts on the advisory committee. So we really have a unique opportunity to learn after my initial presentation also on the beginnings, because we very much rely on the context for monitoring that was set up in the beginning that we take for granted. Visits, country visits, for example. And of course, I would like to, in the beginning, say that monitoring is always a collective effort. So collective effort, of course, by 18 independent experts and by the Secretariat. So in this sense, what I and also my colleagues, what we will be saying, it's really very much some of the perhaps thoughts or issues that we can share because of the collective endeavor by the group of experts together with the Secretariat. And in this respect, we are joined, as we said already yesterday, by Emma and David as current members of the advisory committee, then Melina, Antonia, and Goran as former members of the advisory committee, and also by Dr. Elise Cornu, who's the head of the Division on National Minorities and Minority Languages. And this is important for what I'm going to say when I will be sharing the context for monitoring. So, of course, I mean, we all know in this room how the monitoring functions with a state report, with parallel reports that we now actively seek because the NGO sector is also underfunded and under stress, with visits that, as I said before, we take for granted but are not insured in the treaty. So Rainer will be able to share with us a little bit more of how visits were actually established. And then with the opinion that, again, as we heard Elise explain yesterday, now the opinion gets adopted in 2 stages. This is the new process. The first stage is the approval. This was the normal former stage of adoption. So now we approve it, then we send it to the state for comments in a confidential dialogue. As Elise emphasized yesterday, the idea of a confidential dialogue is to have either recent information, because some states, believe it or not, adopt various action plans right at the time of the monitoring, which we are quite happy about, or even some legislation gets passed because of the monitoring process. The confidential dialogue is an opportunity for us to revise a few of such, to add a few such recent pieces of information, or to correct some factual mistakes. States have 2 months to convey such information to the advisory committee. And then the second stage is the actual adoption of the opinion, which means that the opinion then does not change. And then, of course, the last stage with this is the adoption of a resolution of the Committee of Ministers. Yesterday, we heard Tove say a little bit about her research results from the monitoring of the Framework Convention over 25 years. And as we already heard Elise in her initial presentation, so this new process of adding the confidential dialogue and adopting the opinion in 2 stages has really, first of all, led to the automatic publication of opinions, which is really the key. All my colleagues, as well as I, in my first mandate on the advisory committee 2014 to 18, we remember how eager we all were for the opinion to actually be published. This is now automatic, so after 4 months after the adoption. And then, of course, also the significant reduction of the time for the Committee of Ministers to adopt an actual resolution. So in a way, I also always told my students, have a look at the time period that passes between the resolution, because this is a sign of how politically sensitive the issue is. Now this has gone through the window. Like, we'll have to find different ways of figuring out how politically sensitive individual issues are, pretty much. Okay, so this is very much the process as such. But of course, the key in monitoring the Framework Convention are the context and the challenges that one faces in this process. And I'd like to focus, first of all, a little bit on the context and challenges that I will refer as internal, so that apply to the advisory committee, the functioning together, of course, with the Secretariat within the Council of Europe. And then in the second part, I'd like to focus a little bit on what I would call sort of external. So external to the actual work of the experts on the advisory committee. Now, of course, there are many different actors involved in this whole process of monitoring. It's not just the experts themselves and the members of the Secretariat, but it's also other bodies within the Council of Europe that have a role. We are all part of the Council of Europe. So also when we go to an individual state, often our interlocutors would not know who we are and what we do, but for them, we are often just the Council of Europe. So in a way, we are an organization that should bring about the change that is needed for them to be actually able to enjoy minority rights. You can imagine if you go to all sorts of areas, you face really huge socioeconomic challenges that for these individuals belonging to minorities will not matter which committee you are a member of, but you are part of of course, the Council of Europe. And then, of course, the states themselves, and also the general context in international relations that always has an effect on the monitoring as such, which of course includes also then what happens after all these documents are adopted, because this nevertheless is really, or should be, the actual value, so that you help to bring the change on the ground. And this is something I'll reflect a little bit at the end. So when it comes to these internal context and internal challenges, of course, for the advisory committee, one of the challenges has always been how to interpret the framework convention. So how to interpret this framework that is very general, that often experts would criticize the framework convention of being too sort of general. We have even heard some experts, and we had to intervene a little bit, and I'm not going to name the names, who would say, oh, it's not even a treaty. And, you know, we were in a position often to say, even in international organizations, it is a legally binding treaty, but it's a framework. But of course, it's also when you try to interpret the treaty that is broad and that seeks to provide a framework, that also gives you a lot of opportunity, a lot of space for interpretation. And here I think it would be very, very important and interesting for all of us to listen to Rainer, how actually the committee, the Secretariat really so cleverly invented this article by article approach, and many of the core understandings that still serve the purpose today, that we still often go back to the first cycle opinions to sort of understand how issues were interpreted. And then we try to, of course, do the progressive assessment ever since. So the first challenge, the internal one, is, of course, the interpretation, so the Framework Convention. Then the second challenge that is also, in a way, a good challenge is how to, based on understanding the field from different disciplinary perspectives, how to sort of like what language to use, what terminology to use, and what messages to convey with the terms that the advisory committee uses. Yesterday, there was a lot of discussion after the presentation on data collection, and I'll give you just a couple of examples how careful the advisory committee is with using the terms, because we always believe the terms, of course, matter. And it's by using the terms you are also conveying the messages, although the messages may not be explicit. But yesterday we had this example of an ethnic origin versus ethnic affiliation. So the ethnic origin, of course, would be based on the primordial understanding of you being born into a community versus ethnic affiliation that suggests that, of course, everyone is free to affiliate, which also means that you can change your affiliation over time, that you can have multiple affiliations. So it opens the space for diversity management in a more flexible way that can also change over time. Then another such example that we often also stress is the issue of first languages versus mother tongues. So again, the first language being the more neutral term in a way that also allows the possibility for individuals to change their first languages or to have more than one first language. Because of course, most people would understand the mother tongue being the language you are born into. Of course, sociolinguists would know that mother tongue is really the first language. But again, we try to use the language that opens up the space for the different approaches and different policies that are needed. And the third such example where we spent a lot of time, or just to give you a term as an example, is the issue of integration. We strictly use integration when it applies to societies, suggesting that this is a two-way process, that basically what we need is coherent, integrated societies, rather than persons belonging to minorities integrating, possibly assimilating into societies. So, and here I think it's very important that 18 independent experts, of course, come from different disciplines, from lawyers to political scientists, often anthropologists, sociologists, sociolinguists. And this is the sort of the wealth of disciplinary contributions that we then spent a lot of time also pondering on how to go about certain issues. Recently, we have been facing the issue of segregation that, or maybe a better example, recently we have been facing the issue of integration, that states, of course, understand that integration is needed, even integration of society is needed, but they don't understand the second part, that, of course, integration also includes respect of minority rights. So that some states would argue, oh, we have education only in the state language because we want to ensure societal integration. So we want to ensure that every person of a society can fully, effectively, equally participate in a society, which of course is one side, one important part of the story. But that should not go at the expense of them being able to express, preserve, develop their identities. So minority rights should be always added to the integration. So we then try to see collectively how we can best address such issues. And some of it, maybe just the tip of the iceberg, then is really shared or expressed in our opinions. And then the second method through which we explain in more depth how the advisory committee is interpreting the Framework Convention is through the thematic work. And here again, as everyone knows, we have 4 thematic commentaries. The last one was adopted on the scope of application. So the first on education, effective participation, language rights, and the scope of application in 2016. And at present, the advisory committee is revising its first thematic commentary on education, because a lot has changed since the first cycle in the field of education. Now, of course, this whole internal challenges, I'd say perhaps 2 of them that perhaps are also very important to understand the work of the advisory committee. The first one is that this is voluntary work. So none of the experts gets paid. So this is not the part of the work that one does. So time is an issue. And this is always also very important for us, how we balance in a way our regular jobs with the work that we dedicate to the functioning of the advisory committee and the interpretation of the Framework Convention. And the independence of experts is another challenge. You can imagine that states are more or less prone to ensure independence of experts. For some individuals, independence goes even without saying it or without really wondering about it. But for some experts, independence is an issue. So that states could put pressure on individuals. I mean, often states also try to make the list of candidates that may not necessarily be truly independent. So there are all sorts of issues that are at stake when it comes to independence. One of the issues that the advisory committee has always ensured was that at least you as an expert elected in respect of a state, that's another thing that we always emphasize. So you are not from a state, you're not representing a state, but you are elected in respect of a state. This is something we often even correct our interpreters so that it's clear the message. We, of course, I mean, you are viewed as a national or as a citizen of a certain state, but it's a different thing to have a citizenship or to represent the state. So, and one of the issue, as I said before, just to conclude the sentence, is that you as an expert elected in respect of a state, you never are a member of a working group on that state. You don't vote on the opinion on your state, and also you never participate in neighboring states. In a working group that sort of goes on a country visit, it's usually 3 experts, so you're not a member of that working group on your neighboring states, and you're never a member of a working group on a state that has a co-ethnic minority, we would say like a kin minority, so that you try to be as away from the politics as possible in order to, of course, not just protect your individual independence as an expert, but also to protect the independence, credibility of the advisory committee. Now, that brings me to the second set of challenges, the so-called external challenges and context. Here, there are a number of issues. The first one is, of course, the advisory committee being viewed on the ground as the Council of Europe. This, of course, and the advisory committee is part of the intergovernmental organization. So there is, if I'm very direct, there is a lot of politics involved in the work. And this is the core dilemma that I'll also mention at the end, how to sort of go about this balance between the expertise, the nice, in a way, academic disciplinary contributions, and vis-a-vis the politics. Minority issues are a very sensitive political issue. And I think we'll be all able to say, together with colleagues, that of course, sometimes they're less important or less politicized, but certainly nowadays we are not probably on the top, but we are on the high end of the sort of being on the political agenda, which of course then has an impact on the work of the advisory committee. So one of the issue is negotiation with states to carry out visits. This is usually done with the secretariat, so experts will not be involved directly, but it's not always easy to negotiate a visit that would also fit our, in a way, planning of when we address an individual state. Then 2 more issues I'd like to mention, and that I think for experts is always a hot topic. The first one is the gray zones. So there are areas, as we all know, that are not monitored. So from Abkhazia, South Ossetia, Nagorno-Karabakh, before the recent events, Transnistria, Northern Cyprus, and nowadays, of course, the second issue, the Crimea. So if in the case of the gray zones, of course, there is no state party or the state party does not exercise the control, then the issue of Crimea is, of course, that the state party still, the Russian Federation, exercises control, but then there is the whole issue of access to these areas. So this is something that you see that, of course, experts are ready and capable of doing the monitoring, but it's a political matter for the organization to ensure access, to make sure that the state parties concerned agree on the monitoring of these areas. But of course, from the experts' point of view, even if access were granted to these areas, we often also pondered a little bit about how it's actually even possible to do an independent monitoring if you are in an area that you can also be abused. That, of course, goes particularly, let's say, to the Crimea. That, of course, we know that even if monitoring did happen, then it would be probably quite difficult to talk to independent civil society representatives, independent minority representatives, without the pressure of the authorities, either sitting in the same room, listening, or all sorts of other issues that, of course, one wonders how to go about. And as I'm talking about this sort of context, we often also face the problem of protecting human rights defenders. So often in some states that we refer to as Article 7 issues, so issues with democracy, rule of law, it's difficult, it's not difficult to find independent individuals, but it's difficult to then reflect what we can say we were told on the ground, knowing that these individuals were known to the authorities and the authorities know who we met. If I'm very direct, again, without mentioning individual states. Now, speaking of external challenges, that brings me to the next issue, is the highly sort of like really the politics of minority rights in the Committee of Ministers. Yesterday, we heard already from Tove a little bit about how sort of this goes within the Committee of Ministers. And as I said in the beginning, of course, the Committee of Ministers does not have an effect on the work of the advisory committee, but it sets the context. So it's really the Committee of Ministers that agrees that publications will be made automatically. This is something that, of course, for the advisory committee would be normal without really thinking about it, but we need the support of the Committee of Ministers to make this whole process possible. So in a way, whatever monitoring produces sort of faces politics, faces states sitting in the Committee of Ministers. So we cannot avoid politics as much as we want. I mean, and then of course, depending on states, how happy or unhappy they are with the assessment of the advisory committee. Sometimes you would hear the advisory committee doing the monitoring. Sometimes you would hear the advisory committee advising the Committee of Ministers to do the monitoring, what the Framework Convention says. That's already a sign for us to think, okay, so you are saying that basically it's states that monitor rather than really the experts. So again, there you have the tone that you see that it is, of course, the advisory committee functions within an international treaty in an intergovernmental setting. So politics, of course, comes to play. Then the other aspects of political issues within the Committee of Ministers is what we normally refer to as this bilateralization versus multilateralism. So sort of how interested individual states are in opinions on other states. The kin state activism that we heard yesterday. That is also another matter. And as I said, over time, I would say that with this new procedure, things have significantly improved. But of course, all presidents go to the Committee of Ministers, present the opinions. I'm not sure if we are too public, but okay, I won't mention the names, but I'll just mention what is happening, that often you know in advance which states are going to take the floor when you present individual opinions on individual states. That can be for the good cause. It can be, of course, sometimes as an indication of some sort of an obstacle for the actual adoption of the resolution. But as I said here, I think one should be positive about these developments, which were long in the making, and it was a lot of effort needed, particularly within the how one says structures of the Council of Europe for that change to actually occur. And it's sort of like with the support of some or a number of states, this was then made possible. Then I'll just briefly mention sort of two other challenges. There's often sometimes disagreement between different bodies of the Council of Europe that one faces, how one addresses these issues. The court, the Venice Commission, and a few others that, of course, one then kind of needs to take into account what other bodies have said. And then the classical challenges that we heard yesterday, and I'm not going to repeat, the state behavior itself. So what we face today is, of course, this shift against minority rights, the shift to integration being viewed as assimilation, then all the issues we heard yesterday in the panels on nationalism, quest for homogeneity, protection of unity, all sorts of issues that, of course, we all very much know about. That brings me to my concluding remarks. Of course, all of these challenges in a way put us in a situation that we need to be very precise, then we need to be very good in our assessment that is evidence-based. We need to be very clever in our recommendations that are not too general, at the same time not too specific, so that we take into account the wealth of situations in different states. Because states, of course, always compare themselves. And the last thing one would want is really to be faced with the criticism that you deal or you assess different states differently, which you have to. But for states, we sometimes hear the argument, the more you do, the more critical you are towards us. Whereas you don't say much for states that don't do or do hardly anything. So how do you then balance this approach that you need to take a comparative view, but of course, at the same time, you need to do the monitoring in a specific country context. And my last point is this, in a way, dilemmas. So the first one is, of course, personal issues. So the personal biases versus being a human rights, minority rights expert. This is the first balancing act that needs to take place. The second one is the dilemma between being an expert and being an activist. So we are experts, not ombudspersons for minorities, but we are, in a way, sometimes activists for minority rights, which some minorities, of course, may find it difficult to accept our recommendations that you do the balancing act. Then the dilemma between theory and practice, so what we know as experts and how that is then faced or how that then translates into practical advice. And then the core dilemma that I think was very clear from my presentation, I hope, the dilemma between the expertise, independent expertise and politics. And I leave it at this stage, and I very much would like to hear your assessment, your views, so that, as I said in the beginning, the advisory committee could reflect and be better in its monitoring. Thank you so much.
Thank you, Professor Rotter, for providing us with these important insights and for shedding the light on some important issues that are for sure going to encourage further discussion. So now we are moving towards our next presenter. It is Professor Rainer Hoffmann from the Faculty of Law, Goethe University, and the former president of the advisory committee. Professor Hoffmann, the floor is yours, please.
Thank you very much, Rita, for that invitation, and thank you very much in particular, Goran Basic, for the possibility to be here today and to talk about the beginnings. I mean, if you look at that little booklet which we have, where you see what we were supposed to indicate what we are going to talk about, you will see that that was very ambitious. And I will not be able to cover that within the time given to us. So I thought I would concentrate, having the three of us have been in contact before how we should proceed this morning, that I would concentrate on what I call the beginnings, because as Petra said, I'm probably one of the very few people around who has been in the committee, on the committee at its start in 1998. And what I wanted to do is to, well, first starting by reminding us, all of you, where we were in 1998. Well, from in the historical or political context, I don't think I have to recall that in the city of Belgrade. I was really, I hadn't been to Belgrade for, I think, 6-7 years. And then I came from the, 2 days ago from the airport, being driven into the city. I still saw the ruins of the NATO bombing from 99. That was so many memories came back from those days. So, I mean, just to, re-stress that or recall that the Framework Convention definitely is a child of the early 90s, last century. The wars in Yugoslavia, the Vienna Summit in 93, and it was decided to draft a Framework Convention and not an additional protocol to the European Human Rights Convention. And then, well, we can come up with the Framework Convention the challenges connected with that term Petra has just mentioned. I want but for us, when we started in '98, when we looked at the legal basis, what the framework, what the advisory committee was to do, was, as you can read, we were supposed to be a body to advise, to assist the Committee of Ministers, and we were rightly, I think, called a teethless mechanism. And a colleague of ours, Gudmund Alfredsson, then published an article called the Framework Convention, framed with an incomplete painting. And that was something we did not like very much, but what we came up with, and we had, I must admit, we had about almost a year time to consider how we would proceed. The first meeting we had was end of June '98, and the first first state reports were supposed to come in April '99, so 9 months to consider what we wanted to do. And I tried to formulate what our goal was, that we wanted to become now independent. That was very important. Petra just mentioned that independence both ways as regards states, but also in particular as regards the understanding of our own activities. And there was a situation that we had some colleagues in the committee whom we know were under most considerable pressure from their governments, basically to act as not to forget the government interests of the respective country, let's put it this way. And the whole mechanism that Petra just mentioned, that you are not entitled to vote on the opinion on the country in respect of which one had been nominated and elected, that you are not going to, in the countries that are participating in a working group, which would be dealing with a state where you have a kin minority. All these mechanisms which were developed in those ideas developed in those first 9 months had to do with the very fact to also protect some of our colleagues from the pressure which we knew they were facing at home. I think the next term is really probably what was at the heart of us, that we wanted to become a facilitator of a dialogue, and not, as you can see it in the very last line, not a quasi or judicial organ handing down judgments. And that was something which, when we traveled around really trying to hammer down to governments and to minorities, we are not here to tell you what to do, but we are here to facilitate the dialogue. You yourself have to find a solution for your problems. It's not us who come and tell you what to do. We are in a position after some time, or we will be in a position, now we're talking about '99, we will tell them then maybe after the first cycle or second cycle of monitoring, we might be in a position to give you good examples, best practices. But for the time being, we are here to facilitate your dialogue. But it was also new, I think, when we compared ourselves with the UN bodies and the other Council of Europe bodies, was that we wanted to establish what was then called a continuous dialogue. Marie will later on talk more intensively on the follow-up mechanism, which was also something which I think we invented. Because the monitoring cycle consisted of 5 years. So the normal thing would be that if the state report would come in on time, that would be probably after 1 year. Then we would need more or less 2 years to draft an opinion and get it get the Committee of Ministers resolution. But then there would be usually a time frame of 2 years. And that time frame should be used, in our opinion, to bring parties together again to discuss what is the contents of the opinion, what is the contents of the resolution, and what are the ways you, state officials and minority representatives, can imagine to implement those recommendations, so that they would prepare for the second state report and come up with some ideas themselves. So therefore, continuous, sort of not one, we would meet and then we stop, but it should be continuous. And as I said, we were we wanted to keen on establishing this dialogue, not between ourselves and state governments, between as a tripartite system, if you want to call it like that, state representatives, minorities, and possibly to some extent, well, separate from that, civil society, then, of course, ourselves. And I mean, if you see that, then you recognize the normal setup of a country visit. I mean, you always meet with governments, you then meet with people representing civil society, not necessarily minority representatives, then minority representatives again. So that was a setup developed then. Also, the idea was then, or the decision was taken, that we would try to highlight progress made, so kind of sort of commending states for positive developments and establishing these best practices, which we could recommend maybe to other states later on. Very important, I mean, that was probably, I mean, the term that you see there based on sound legal reasoning, that was probably to do with the fact that at the beginning, the membership of the advisory committee was very largely dominated by lawyers. That was also something which was then later on rightly criticized, I suppose, and that's why during my second term as president, we really tried to get away from that predominantly lawyer composition of the advisory committee to include much more political scientists and social scientists. And I think that is, I mean, I have no idea how it works now properly, but how it works presently, but I think that the balance is better than it used to be in the early days. The final point, I think, which was very important and was not that much welcomed by all member states, that from the very beginning we were determined to treat all states equally. If you look back in the early 90s, I think it is fair to say that the Framework Convention was considered by the old Council of Europe member states as an instrument for Eastern Europe and not for Europe. And I remember that it was not always that easy in the very beginning to go to the Committee of Ministers and to explain why state A, B, or C, which was an old member state of the Council of Europe, was, in our opinion, failing to comply with its responsibilities under the Framework Convention. And I can remember a number of, I think diplomats talk about frank exchanges of views, and that's what we had there. I mean, maybe you could be kind enough to keep those terms in mind, so that maybe would be a basis for later on finding out to what extent we managed to get there. So how this teamless mechanism? So how did we try to overcome that? Maybe I should say or mention now that also refer to 3 persons which I think were extremely important at that state. My 2 colleagues from the Bureau, Gaspar Viro, the colleague from in respect of Hungary, himself as a member of the Hungarian minority in Transylvania, who had very good contacts with the Hungarian government, which at that time was not Orban government. Let's leave it like that. We then had Alan Phillips, who we all know was essential for the setup of the Framework Convention and most regrettably passed away this spring. Otherwise, he would have been with us today and yesterday, who had been involved in NGO work, and he knew how to open doors, and who happened to be knowing the British ambassador to Strasbourg. The German ambassador was a close friend of the judge for whom I had clerked with the Federal Constitutional Court. So also that opened doors. And then there was Antti Korkiakivi, probably the most important person in that context from the Secretariat, one of the most creative lawyers I've ever met. And he had, contacts with the Finnish government, let's put it this way. So the first thing we needed was to get out of that situation. We sit there, wait for the state report to come, comment on it, and that's it. That was something we did not want to do. So I mean, you must imagine we had to ask the Committee of Ministers for permission to, for at least a limited time in the beginning, for 2 years only, actively seek information from state authorities. And the idea originally was, you sit there, you get what we give you, and that's it. And so, I mean, that ended up that we would be drafting an outline for state reports, telling them what we wanted them to tell us. Then Petra mentioned that alternative reports or NGOs actively contact NGOs. That was not very much welcomed by a number of states, as I remember, but because they considered them to be well, not really reliable and not responsible and whatever. The next point was there was in that resolution 97, some states had managed to introduce in that document the possibility to request a meeting with the advisory committee. So we approached some governments, and maybe I should, just to explain how it worked in reality. Every Monday in a week when we had a meeting in Strasbourg, we had a non-meeting with a number of ambassadors at the residencies, and would tell them what we would like to achieve, and they would then advise us how we should proceed. And that is, many of those permissions we received were prepared in that context. One of them was the idea of Antti to ask the Finnish government to request a meeting in Helsinki. Okay, obviously we had to ask the Committee of Ministers whether they would allow us to meet, to follow that request from the Finnish government. Of course, that it would be very impolite not to allow us. And then within 2 weeks, we got 5 more requests for meetings in the respective countries. And that's how country visits were established. They're not foreseen anywhere, definitely not in the Framework Convention, not in that famous resolution 9710. It is all practice. And that also means that, from a legal point of view, you could maybe argue that it's some kind of customary practices, but it's still not there, and I think that is sometimes important to remember. And it developed then, those countries developed then from not only going to capitals, but also going into the countryside and to, in particular, to go to the areas where the minority reside, where they live. And all of you know that it does make it enormous difference when you come to a place and you see other really bilingual topographical signs. Do you hear the language spoken in the street? You get a completely different feeling than if you're just in capitals. And also you meet, I think it does make a difference if you meet local representatives of national minorities, and not only the functionaries who represent the minorities on the state level. That was the procedural aspects. Then in the external ones, then that is something Peter also referred to. How those opinions were drafted, indicating both positive aspects and what we call then called outstanding issues. The term was very, very consideredly chosen, and it should not sound that critical, but it was for that dialogue which we wanted to facilitate. Maybe we keep that in mind, that in our opinion this is an outstanding issue. Peter mentioned the really the difficult issue of transparency, how to get those opinions public. That is one of the definitely of the advantages of the new procedures. I'm not completely convinced that this informal dialogue is such a good idea, but never mind, it's there. How to get states to public them as early as possible. Again, there are a number of countries in Europe which have Freedom of Information Acts, and according to their legislation, the very moment the opinion of the advisory committee had been submitted to the Ministry of Foreign Affairs, it was a document which would fall under the Freedom of Information Act. So if one happened to meet a member of an NGO and tell them, well, in your country you have a Freedom of Information Act, so why don't you ask your government whether the opinion of the advisory committee has already been submitted? And if so, under that paragraph of Freedom of Information Act, I'm entitled to have a look at it. That worked, and if governments had to publish those opinions anyway, the next step, of course, was to be, well, I'm a good guy, I do it deliberately. You could influence to some extent, but that did not work in all circumstances. Well, our relationship to the Committee of Ministers. I think it was originally not foreseen that the advisory committee would come up with proposals for resolutions. I mean, it's not drafted that way, but I mean, the recommendations at the end of the opinion that they were considered to be, in fact, a proposal for the Committee of Ministers what to take up in their resolutions. And yeah, to some extent, I think it worked. I should probably also say that during the first 6 years, of 1998 to 2004, the general attitude towards minority rights protection in Europe was rather benevolent, very positive, and it changed, and it did change apparently over time. And indeed, in 2009, then was back. We started this development that you would have governments, well, less bilateral fights over wording of recommendations in the Committee of Ministers, which was not that strong, let's put it this way, in the first year. So that might have to do with the fact that governments had realized the impact of the opinions and of the resolutions on their internal situations, that indeed national minorities would increasingly rely on the opinions, that they would come up and say, well, listen, look, the Committee of Ministers has called upon you to do and do that. And that suddenly, I think that had checked, that was something which was understood, which was not that clearly understood in the early days, but that states had understood that then. Then we have the, I already mentioned that, and as Marie will talk about that more in detail, the follow-up mechanism. Then we had, well, that is internal working procedures. Petra mentioned already that country-specific thematic working groups, although it took until 2006 until the committee adopted its first thematic commentary, mainly due to the work of a colleague of ours here, who came later also president of the advisory committee. Then Petra explained the role of the experts elected in respect of a country, the need to safeguard independence of experts. One of the components of that independence is that it was established that an expert would resign if she or he would be promoted to take over the position as an ambassador or high ministerial official. So I mean, really to make to show that that sentence independence must not only be guaranteed, safeguarded, must only be seen to be safeguarded. Then we had, of course, I mean, that comes over time, country-specific and thematic expertise among the members of the Secretariat. And I mean, I can't but agree with Petra and the essential role of the Secretariat and its members over the time. I mean, we are always talking about the advisory committee. I mean, in fact, it's the Secretariat which is doing most of the work because, well, as Petra said, we all have other jobs to do, and yeah, the Secretariat is the Secretariat. So that is, I think, is something which has to be over and over stressed, that it's really those the colleagues there who carry the burden of the work. Yeah, well, we were not known, so we had to make ourselves known. So there was, unfortunately, those days, there was already zero increased budget, but still we were able to follow invitation that we come to conferences to talk about the Framework Convention. You can see all what we've done. The homepage was developed. People wrote about the work of the committee. Stagiaires were accepted at the Secretariat, and I mean, all of you know that you can't have a better investment in human resources than investing in young persons. And I'm looking now at Emma. The first time we met was about 21 or 22 years ago, when she was a stage at the Secretariat, doing her stage at the stagiaire at the Secretariat. And I'm quite sure that there are a number of other persons who have a similar, maybe not the same career. I don't think there's anyone in the advisory committee who started as a stagiaire, but otherwise. Then cooperation. That was very important. We had from the very beginning a really good relationship with the High Commissioner, and yeah, I think it was always he, so his, no, it was a Finnish colleague at some time. So there, the colleagues there, and very often I think it was more kind of an informal cooperation or informal contacts. And I remember that it was usually part of meetings of country visits in two countries where the OSCE had an office, that we made sure that we would meet with colleagues there. So I mean, to get their opinion, get their impact. And there have always been, I don't know whether that is still the case, some sort of informal contacts with persons which we really relied on or felt that they could be confidential contacts with, sharing information, how to formulate certain aspects of an opinion. The EU in the beginning did not, were not really very much interested in the work of the advisory committee, which you can see when you look at the screening reports for the first round of Eastern enlargement. There's only the report on Cyprus, where the Framework Convention and the ASCFC is largely quoted, not in the others. That is already different when it comes to Bulgaria and Romania, and very much different when it comes to Croatia. So over years, that has changed. And of course, since the cooperation agreement with the EU and the Council of Europe 12 years ago or whatever, there is close cooperation. And my understanding is that if you now travel to a country where there is an EU mission, that is usually also one of the people you meet. UN, I don't know how that, must admit that how that works right now. That was more difficult in the beginning, but that was towards the end of my first mandate that we had established contacts with them. There was also contact, of course, within the council, language charter, COMEX and ECRI, and at some stage was introduced a regular meeting, which I think still take place, of the presidents of the various monitoring bodies. There was lots of talk about increasing synergies between the Charter and ECRI and Framework Convention. I simply don't know how that situation is now. I mean, we had a number of common or joint country visits. I'm not sure that, well, I would not call them a success, so that might have been simply a situation in that case. Now, a few substantive issues. In the beginning, 98, the focus was on security matters. It was, well, Kosovo was still to happen. And the prevailing idea among the members of the committee was that the major task of the committee was to play, well, probably an insignificant, not a significant, but a small role in preventing developments to occur as they had led to the wars in Yugoslavia or in the Caucasus. And so the conviction was that persons or minority or the members of a minority who feel that they are integrated or that the majority of the population is welcoming them, and that they are welcome to be integrated, to have a truly integrated society, that they would be, that these persons would be less keen on secession, whatever. So the idea was that if minority protection would contribute to a truly integrated society, then there would be less risk for violent development. So that was, I mean, how we started, and that all. Then the next thing was then general human rights issues. I mean, we always considered minority, that persons belonging to a minority obviously are holders of all general human rights, but in order to preserve and promote their distinct identity, they need these additional rights. So that kind of affirmative situation. And that, I think, was the prevailing situation until the 2002, 2003 maybe, and then that changed, and it turned into what I now call, I mean, we can talk about terms, embracing diversity management. That was nothing which was around in the end of the 1990s, and I think that has become the predominant feature of the work of the advisory committee. Until, I'm afraid, recently, I mean, the situation in Ukraine and the situation in the Caucasus tells us that the times are not over. Then something new was also that, I mean, human rights bodies had a focus on vulnerable groups, in our context, mainly Roma. But then I think the addition was vulnerable groups within vulnerable groups, women and girls, that double discrimination effect. I think we began then with the standard setting, and I think nowadays it is quite normal that bodies in Europe, the EU, when they talk about the accession development with Ukraine and looking at the new Ukraine law on national minorities, the yardstick the EU is using is the Framework Convention and the opinion of the Advisory Committee. The same happens within the Venice Commission. So the Advisory Committee has, or the Framework Convention, as interpreted by the Advisory Committee, put it this way, has become the major source of reference for European standards in minority law matters. Then we have
Professor
defined.
Hoffman, can I ask you just to go towards the
Yeah,
conclusion?
and then we have defined terms as traditionally inhabited or inhabited in substantial numbers, I mean, what that means. And then the article by article approach that was based on the understanding that in the 90s it was still unclear whether so-called new minorities would be covered by the Framework Convention. Then simply, it sounds very simple looking at the text. You would have a number of articles which from their wording would clearly apply only to traditional minorities. Then you would have a number of articles which clearly would apply to everyone, Article 6 in particular, intercultural tolerance and measures against hate speech. And then you would have the other provisions which could be interpreted in such a way as to include all kinds of persons, but not necessarily. And then that was sort of the approach to it. The final word on Article 3. Applicability of the Framework Convention on groups of persons, and that was developed in the first cycle of monitoring with respect to Denmark. The determination of a state in its instrument of ratification of a state report, which are the groups covered by the Framework Convention, is first the state's decision. But it is within the competences of the Advisory Committee to decide whether this decision to exclude a group or not is clearly wrong. It's not justified. In that case, it was the Roma in Denmark, and that has been, I think, maintained as an approach. But it has been used usually in such a way as to propose to the state parties concerned to get into contact with the group which is aspiring to fall in the scope of application of the Framework Convention and to develop a common solution. In some cases that has been successful, some cases that has not been successful. Thank you for your patience. Thank you. Sorry for being a bit too long, and obviously looking very much forward to questions on those early days. Thank you.
Thank you, Professor Hoffman, for highlighting the challenges in establishing the work and procedures back at that time after the ratification of the Framework Convention. And finally, our third presentation is the one by Marie Hagsgaard. Perfect, right? Practice makes perfect, right? So let's hear something about the practical solutions and the practical implications of the Framework Convention. So please, the floor is yours. Thank you.
Thank you so much. And let me begin by saying that I was so inspired by yesterday and the presentations and discussions we had, because I think working with the human rights of national minorities will always be difficult. But all of us here, we are trying to do our best to push things for effective equality for persons belonging to national minorities compared to the majority. And I mean, it's so important. We cannot give up. So I'm very glad. Thank you, Goran. Thank you, your colleagues, for arranging this conference where we can strengthen each other in this work. And Rainer talked about the advisory committee being a body that can support the dialogue between persons belonging to national minorities and states. And I think that's a key issue. You know, my background is as a judge, and as a judge, you have the laws. And what you do daily is to implement the laws. You have concrete cases and you implement the law. So then when you implement the law, I did criminal law. Somebody, you know, this is not acceptable in our society and this is the punishment. And the victim gets a sort of message that this was wrong and what has happened was not good for you. You could apply the same view on the Framework Convention. We cannot not only have this wonderful Framework Convention, it's not even enough with the minority laws that we see now all over Europe. They have to be implied so that persons belonging to national minorities can see that they get their rights exactly like other people belonging to the majority. So I'm going to focus my presentation on the follow-up meetings that have existed for a long time, but I think could be used like something that the advisory committee could offer to states, because it's states who invite us to come to follow-up meetings. If they decide not to have a follow-up meeting, there will be none. But we could offer to assist them in follow-up meetings as a tool for constructive dialogue between representatives of national minorities and states, with the aim to find those practical measures to implement recommendations. And I will be interested in hearing if you think it's possible. So why did we start thinking about this? I started as a member in June 2018. And in January 2019, there was an informal brainstorming ahead of the 5th monitoring cycle, where representatives of state parties, and they were chosen like, you know, some are very positive to the way the advisory committee is monitoring, and some are often very critical. So we tried to choose representatives from both sides. So they came from Austria, Finland, Hungary, Romania, Slovenia, and Switzerland. And we were 3 members who met with them, and also members of the Secretariat in January 2019. And they did say some very interesting things about the follow-up meetings. They affirmed the value of the follow-up meetings to discuss the findings of the monitoring cycle with the advisory committee and minority representatives, and to assess how to best move forward on the implementation of recommendations. And later in the discussion, some of the states sort of tuned up this with expectations, and they expressed the wish to have more concrete recommendations, some wanting clear guidance on options of how to achieve a given recommendation. And I have filled in the rest here. States noted that there was often an appetite for change in their administration, but sometimes no clear idea of how to achieve it, and that they wished that the advisory committee could show a clear pathway to implementation, for instance, during a follow-up event. So this started the thinking from the three of us who attended this meeting. So what did we learn? We did not want to tell states exactly what to do. As Rainer said, this is not in all, the thought behind the Framework Convention. But we draw the conclusion that follow-up meetings needed a clearer focus on practical measures in order to contribute to a more comprehensive implementation of the rights of the Framework Convention. So, you know, it should be implemented on grassroots level somehow. What would we do? Well, we started to practice then to try to make follow-up meetings with a focus to assist states and national minorities in finding practical measures that are both important to persons belonging to national minorities and feasible from the point of view of the state. You have to set somehow realistic goal. The important thing is that we don't repeat, like I saw already in the beginning of my period, we repeated the same recommendations for certain states, like my own state, Sweden. Always, you know, they didn't have enough influence, persons belonging to national minorities. So we needed to help states and national minorities to find some progress within those areas. So 3 questions arose. Who should take part in the follow-up meeting? How to prepare follow-up meetings? And what to do and achieve during the meetings? Again, I mean, states are the hosts. So, you know, in a formal way, they decide who to invite. But of course, we could help them and recommend them on who to invite. So, ideally, 1 or 2 members from the advisory committee offer to act as moderators with the aim of finding practical measures to address recommendations. It should be one of the members of the working group, because then you've been in the country, you have met representatives of national minorities and representatives of the state. So you have a better knowledge of the country. The national member should be there. The national member, of course, has an even better knowledge of the situation in the country. And the administrator who planned and took part in the country visit with her contacts is extremely important, because you need to contact both national minorities and representatives of the state in advance of the follow-up meeting. Of course, representatives of national minorities, this looks simple, but I mean, what representatives? How many? I would say, ideally, not too many, because you need to get that dialogue going during the follow-up meeting. And if you have too many people, it may be harder to get results out of that dialogue. And representatives of the state, authorities, politicians, and other stakeholders, and with the aim of having people who can take action to realize practical measures. And the preparations, they take some time, but I think without them, you won't reach the goal, so they are important. To address recommendations, look for good examples of practical measures implemented in other states. And you mentioned this, Rainer, that you made an effort to find those good examples. And I think during my time, we discussed we needed to do more of that, because then you have more to bring as best practice examples to other states. In advance of the follow-up meeting, you need to contact representatives of national minorities and ask what practical measures are important to them in order to address the recommendations from the advisory committee. And then also inform them of best practice from other countries so they can start thinking of that. You also have to contact and inform state representatives after having spoken to the representatives of the national minorities of the wishes of the national minorities, to prepare them and ask them to prepare to present measures that are feasible to implement during the next monitoring period, if possible, with a timetable for implementation. Inform them of measures implemented in other states. And I mean, I believe that most states want to do a good job. So if you contact them and you have concrete wishes to convey from the national minorities, and they have some time to work with this before the follow-up meeting, you have made your preparations in a good way. So during the meeting, what to do and achieve. This representative from the advisory committee should explain the recommendations for immediate action with a focus on those which could lead to practical measures. Now you know, because you've been in contact with national minorities and also with state representatives. And if applicable, you tell them about best practice from other countries. Then you ask the representatives of national minorities to give their view of practical measures, the most needed to address recommendations and why they wish those measures. And Goran, I remember the follow-up meeting we had here in Belgrade, where we had a lot of representatives from national minorities. And I especially remember a Roma representative, a woman who really spoke up and told us what was the most needed for Roma at that, in the middle of the pandemic in Serbia. So it is very good when they are prepared and they do this, because state representatives sit there and we're there to facilitate. So after you've heard the representatives of the national minorities, you ask the representatives of the state to give their comments to the suggestions of the national minorities. And ideally, they have known this before the meeting, so they are prepared to give an answer that could lead to something. Then you have to take a break, because that is the moment when the member of the advisory committee, the national member, and the administrator from the secretariat need to discuss what practical measures are the most urgent for national minorities, what have we heard, but also feasible for the state, what have we heard from the state. Maybe there is just a seed that could grow, but we heard something. And then after that break, you, from the side of the advisory committee, say, we have heard you, and this is the possible practical measures to address recommendations that we have heard you say is possible and needed. And ask representatives of the state to confirm that they could be implemented and within what time frame. And last but not least important, take notes of the above and send minutes as soon as possible to participants as a record of what was said, what was wished, and what was agreed during the meeting. This can be the base for a roadmap for implementation of practical measures to implement the recommendations. So, what was the experience of trying to do this? My experience was that follow-ups like this can contribute to a better implementation of recommendations. And as I said, preparation of the meetings, contacting and listening to both representatives of national minorities and states is crucial. that is when the dialogue starts. Having follow-ups in real life, because I did have a follow-up meeting with Ireland online, you know, it's not the same. You need to meet people in person, and you need to meet people during the coffee breaks to make this happen. And it is very important that representatives of the states are persons who can take decisions on practical measures to implement recommendations. Focusing the follow-up meetings on agreements of practical measures. You get tired during those meetings, but they have to end by some sort of, you know, the conclusion is that today, as we hear you, you have made the following agreements. And that the ambition from the state is to implement them in the next monitoring cycle, not in the distant future. So, if done like this, I believe that follow-up meetings can contribute. And the role of the advisory committee is to assist states and national minorities in a dialogue where they can find those practical measures that are both important to the minorities and feasible from the view of the states. But also the follow-ups need to be followed up for best effects. And maybe here researchers could be a part of the following up to see if practical measures are implemented and what the effects of those measures are. But again, it has to start with the possibility for the advisory committee to put down the time needed for preparing such meetings and doing these meetings with a clear focus on agreements of practical measures to implement the recommendations. It's not easy, but I think we need to try, because we don't want those repetitions of recommendations when nothing has happened implementing the previous cycle. Thank you, friends.
Thank you so much, Ms. Hagskor, for your very interesting presentation. And as a chair, I found it really difficult to interrupt our three speakers at one point or reminding them of the time, which is very limited. It was very interesting, and I'm sure that it will provoke a further discussion in the time that we have, more or less 10 to 15 minutes, if we are to start the next panel on time. So please feel free to comment, to raise some important questions. Our colleague Ljubica Đorđević is the first one to give the comment.
Thank you very much. I rather have questions to Ljubica Đorđević, European Center for Minority Issues, Flensburg, and Head of Cluster Justice and Governments. I'm emphasizing this because the core of our activity is actually European legal framework, meaning also framework convention. And for me, it's really was very helpful and insightful to see behind the screen, because we usually get what is output. So this was very helpful. I will not comment, I will have questions, because I will use this opportunity to get behind the scenes, as I said. So questions for all, maybe Petra and Rainer, but for all participants. First, Petra, you mentioned that you do and rely on evidence-based monitoring. For me, the question would be how you secure this evidence-based, where is it, and how you actually perform this evidence-based monitoring. The second question is, how do you secure consistency and continuity, bearing in mind that people change both in the advisory committee and in secretariat? So how this then this is a challenge, I would say, and how you manage to secure this. And second question, and third question, and last is, how do you assess the feedback from the member states and impact of your work, but their feedback and resonance to your recommendations? Thank you very much.
More questions, or are there? So first Petar Antić and then Rubin Zemon.
Okay. No, it's taking here. First, I would like to thank you for your amazing work in last decades in related to the Framework Convention of National Minorities and all these obstacles and challenges which you actually had. You explained in your presentations, but there are many of challenges, and I can see from Petra's, for example, presentation. There was the concept to not have neighboring states even in the work of the working group, which is interesting from the point of view of the concept of the kin states, which actually challenge even the principle of non-discrimination, which is proclaimed in usually in our constitution, and also challenge the joint identity of belonging to the state. And what do you think? Because there are now opponents who are actually advocate for including the standards and principle of the kin states in international law, which was we have reluctance actually in international law. There was no even this term in the international law used before. What do you think? How in future to deal with this? Do we actually should we actually use the term? Because as you said, the terms means are important, and somehow if we use the term kin, I think opposed to non-discrimination because an idea of the national states, because I cannot walk to two directions at the same time. I can walk to the national way of thinking in national states, or I can walk to the idea of the citizen states. We cannot walk to the two directions at the same time. We have to choose.
Thank you, Peter. And now Ruben Zeman, please.
Thank you, Ružica. First of all, I want to say thank you to Goran and to Institute for Social Sciences for this excellent opportunity to have here today. We as researchers and also the member of the advisory committee to have such a valuable meeting. Thank you to all the presentations today. Really, it was enjoyable to hear of you. I have a question for the three of you, actually. For Petra, actually something similar like Georgievis said about the implementation of the recommendations and the constituency of the recommendations of the advisory committee, because as now I made also in this publication about the Macedonia actually. So what was recommended in the first, second, third cycle, and it's not implemented. So we are now, it's disappearing later in the fourth and the fifth cycle, the same recommendations, even they're not implemented. So how we can ensure that actually the those recommendations who are actually given by the advisory committee will be implemented, especially for those countries that now actually in the process of negotiation from the European Union memberships, and in, of course in some of them started the negotiation processes, especially for the Article 33. Yes, about Hofner. You said that advisory committee, of course, is not a judgment body, but we have some cases like Bulgaria, for example. We have 16 judgments of the Human Rights Court from Strasbourg regarding the minority rights, actually regarding the registrations of NGOs of the Macedonian minority, and they are not respected. So I think that probably the advisory committee also have to push and to be an instrument that have to implement the judgment of the Human Rights Court. So what is your opinion about that? And about Mary, thank you for your presentation, for the follow-up meetings. And yes, we had with Emma, I think this year was, it was very nice follow-up meeting for Macedonia. But also I think when you're talking for this region, for the Balkans, we have the so-called phenomenon of tokenism. Actually, tokenism is that not the real, how to say, activists or representatives of the minorities are coming to express their concern, but somebody who is very close to the government is coming there and speaking. So maybe we have to care about also on all these also reports. I never see in the reports of other committee or opinion that the issue of tokenism is somewhere indicated. Thank you very much.
Please, Professor Petričiūčić, go ahead.
Thank you. So many questions so far. How do we get to them? Let it work. So I will try to ask. I will try to ask a short one to Petra. I was mostly intrigued by something that you said today, that is implicit aim of the advisory committee to promote integration of societies, not assimilation or only integration of minorities. I remember very well that was part of your speech or address at the conference last year in Zagreb when we were marking the 20th anniversary of the Croatian constitutional law on the rights of national minorities. And that's at the end, it's the goal of Ljubljana guidelines on integration of diverse societies that were put forward, I believe, 10 or even more years ago by the High Commissioner on National Minorities. In your impression, Petra, is advisory committee doing sufficiently enough in order to promote that idea of integration, being exposed to very serious political mobilizing far-right ideas in many of the member states? And is integration a solution, given that national minorities are the mandate of the advisory committee, and there are so other ethnic groups that we cannot insist, and we don't have a legitimacy or a mandate to insist on their integration? So how do you see the role of the advisory committee in promoting, indeed, integration of societies in the period to come?
Thank you, Professor Petričiūčić. Now, to Professor Ana Čupeska, and then after that, Emma Renčina.
Hvala puno svima. Čestitke za prezentaciji, za organizaciji. Zanima me, Petra je pomenula da postoji dilema u svezi kombiniranja političkog momentuma i ekspertskog momentuma. I sad htjela bi da pitam malo više da objasni oko toga, zato što svi smo na stavu, mislim da je očito da nema mogućnosti da se to promeni. Mislim, ovo je političko pitanje, uvijek su minority rights a political question. So, what is your opinion how to accommodate both dimensions, or let's say tensions in that respect, and to normalize this, let's say, false dilemma, whether this should be political or because any expert can't be asked for not to have political opinions. I mean, this is also a legitimate question. If you are an expert, it doesn't has to do that we are not in hard science fields. We are in humanities, in social sciences. So it is something that we can't escape, even as an expert. So we can't be forbidden to have moral and also political views in terms of democracy and human rights, of course. Thank you.
Thank you, Professor Čupeska, and now Professor Renčina.
From
Thank
where
you.
to?
I have the mic here.
Oh, okay.
Because-
Sorry.
Yeah, just leave it on. A quick question to Rainer to take advantage of his knowledge from the beginnings, and we discussed it on our way here from the hotel already. So, and also to link it a little bit to the discussion we had yesterday about kin state activism. So, can you just tell us how you dealt with, because it was in 2001 when the Hungarian authorities came up with this status law for Hungarians living abroad. And if I haven't looked into the Hungarian opinions of this period, but if I remember well, this has not really been addressed by the advisory committee back then. So, but I'm sure that there have been discussions in the advisory committee about how to go about this issue. So for us now, we are again in a situation where we will have to deal with this, and we would want to make this more clearer also in our opinions. So it would be good for us to know a little bit about the reflections of the very early advisory committee on this issue of in-state activism and how this can be addressed under the Framework Convention.
Okay. And we will draw the line with the question from Professor Dejan Jovic.
Yeah, thank you for the presentation. My question is this. We have some groups that actually reject to be called minorities, and they do not accept that. How do we deal with these groups? I mean, do we include them or not? For example, Croats in Bosnia, for example, Albanians in Macedonia. I'm not sure about Serbs in Montenegro. So are they really national minorities? Are they really in your focus or not?
Okay, so I think that we do not have any more time for more questions. So thank you all for your questions and comments. And now it's up to our presenters and panelists to provide the answers and their comments. We will start with Professor Hoffman, maybe. Thank you.
Thank you very much. With the first question, evidence-based. The motto at the early days, and I think it still is the case, is do not take anything up in your opinion unless you're absolutely sure that it's correct what has been told. That is what you have to do. I mean, you are relying on media reports, you're relying on judgments, you're relying on what national minority representatives tell you. You can ask state officials. And if at the end you are completely convinced that that is true, but I mean, and I suppose that has not changed over the last 10 years. The guideline was only address things in your opinion if you're 100% sure that it is correct. I mean, there still might happen incidents where you come up with wrong information or fail to control that properly. And that I think is one of the major reasons for that process of confidentiality. I mean, I remember one case when we criticized a certain state for having a Roma settlement walled in, and later on it turned out that the wall was built between the settlement and the motorway, and we had not checked that. That was embarrassing. About well, consistency and continuity, it's an issue, but I think that has been dealt with both by the Secretariat. I mean, there are persons who've been there for a longer time, so they would remember what we have done before. I mean, you have the opinions that you can see, and I think over time, I mean, you develop in body like an advisory committee a kind of language of your own. And I mean, you see a situation with grave concern, you see a situation with concern. You doubt the compatibility with, and then you are concerned. I mean, that is possible, I think. And then you also have the situation that many people or many members of the advisory committee have a second term. So I mean, that also adds to that issue. Maybe just one point to the national, the expert elected in respect of one country. I mean, the approach taken by the advisory committee is not the only one. The language charter does it completely differently. And there, the expert on behalf of the country is really fully integrated into the working group and is an essential part of the working group. So the reason why it has been done and it still is done in the advisory committee dates back to the early days. And I think also nowadays you include the national member or the person much more than it was done in the beginnings. At least that was what I recall from 2008 to 2012. Uvin, yes, indeed. The very cases you are mentioning should be taken up, and I think they are being taken up by the advisory committee under Article 15, because obviously it's a matter of effective political participation if the associations are banned. But the difference between the European Convention on Human Rights, it's the court deals with individual cases, and the framework, this convention deals with systemic problems. So I mean, that is the old discussion whether you really should have I mean, you could have individual complaint system, additional protocol, but that would be the very case would, the decision would be on one issue. And on the other hand, we all know that a number of court rulings did change the situation. I mean, referring to the court cases, the rulings on Roma discrimination and access to education, starting with E versus Czech Republic, and then you have the cases against Hungary and other countries. So it might help, but the approach is different. And I think there is also, the chamber judgment in E versus Czech Republic did not refer to the Framework Convention. The Grand Chamber did. And that was, I think, a time when the court realized that there is something like the Framework Convention and the Advisory Committee, and it has been relying or referring to the Framework Convention. More than that, and I would be surprised. I have not read the recent opinions on Northern Macedonia, to be correct, or North Macedonia on that issue, but I would expect that we will refer to those issues. Yes, I mean, experts obviously do have political opinions, and I think everyone sitting on the committee has his or her opinion how to promote and preserve national minorities' interests, and that flows into your behavior in the committee and what you want to do, of course. But still, I mean, I think what is important is that you are there not defending or fighting for the interests of your country, so to speak, but you have to keep in mind or see the whole European picture. That is, in some instances, that might be difficult, but I mean, that is always when you are working in an international body, or being in the country of Europe, the EU, OSCE, whatever. I mean, once you are in a position, you must try to forget what nationality you have. Emma, it has to do with the time framing. The first opinion on Hungary was adopted in 1999, and this next one, I think it was adopted then in 2003, 4, something like that. And I don't recall it now, but I know that when then there was the Venice Commission was charged or tasked to report on the status law in 2001, and I think we refer to the issue in the second opinion on Hungary. And I would guess that it was under Article 17, but I do not really remember. I mean, what the point was that, I mean, I think we accepted, or we thought that the gist of the opinion of the Venice Commission was, in principle, it is correct for a state to adopt measures in favor of its king people, unless they are sort of respecting the territorial sovereignty of the other state. So, I mean, it should be done in cooperation with the state. So in that case, it was in particular Romania, which had complained about that, and that there should have been, and that was a criticism, that there should have been talks between governments in Hungary and Romania before, and then that there was a discriminatory effect. And that was, I think, if I remember correctly, somewhat left not very clear in the Venice Commission's opinion to what extent the status law actually came up to discrimination of ethnic Romanian when it comes to access to all kinds of benefits in Hungary. I mean, it was fellowships, scholarships, and all that. That was the point of view. And usually, that is my second term in 2008, 2012, the issue came up, and if I remember correctly, we used to deal with it under Article 17, I think. So that kind of aggressive in-state. But in principle, I think the position of the advisory committee was always that if support by a kin state is done with the consent of the receiving state, it is highly recommendable. And I mean, for example, providing curricular materials, teaching materials, education materials to send teachers, if the state wants them to be there, that is fine. And what was considered to be problematic, and I still think it is very problematic, is, I mean, if you establish two categories of citizens in a neighboring state, so your own citizens and the other one, and that should be avoided. But what I think was maybe more or less, yeah, I think that's what, I mean, the last question was probably more.
Let me then just briefly say that during my period, the Secretariat took a very commendable initiative, and that was to start a source book where members, after each opinion had been gone through the first time, we recommended well-worded assessments under different articles to be put in the source book. So now there is a big source book with wording of assessments that we think are good, made in a very good way, that the Secretariat uses, so that, you know, when you read the opinions from the advisory committee, you should recognize some assessment, or the wording of some assessments. And also we have, I forget the term, a sort of dictionary in English and French with, you know, carefully decided wording for different things. So even lawyers should be content in seeing those exact expressions for the same kind of thing we want to describe.
Just say one word to Kozajovic questions. A very good one. If you look at the Sami people in Northern Europe, the Norwegian Sami told us that they don't want to be covered by the Framework Convention. We are an indigenous people, not a national minority. The Swedish and the Finnish Sami told us we are an indigenous people, but at the same time we are a national minority and we want to benefit from the possibilities of the advisory committee. So it's up to the group whether they want to be covered or not. That's the first thing. I mean, you must, obviously, it has to do with self-identification. I mean, you must not be told you're a member of a national minority. So if they don't want to be covered, that's fine.
And they can also change their mind, because the last time Norway was monitored, the Sami wanted to be monitored by the advisory committee.
But apparently the advisory committee is on probation. If they benefit actually, then they continue to avail themselves as a minority. And if nothing changes, then they may change their minds. But I think one other aspect of this sort of being considered a minority or not, for the Bosnia-Herzegovina situation, we covered the issue of, let's say, segregated education under Article 6 as an issue of societal integration. So that then, and the other aspect is that we always try to promote the Framework Convention, not as a convention for minorities, but as a convention for diverse societies. So that if you are in a minority situation, you don't have to be a minority, but you can still benefit from access to rights. So that's the logic. But it goes back to, if certain communities do not want to be viewed as minorities, we don't view them as such or treat them as such. Emma will also be, as the first vice president, will also be able to share some of the answers to this, like during the break, because we don't have enough time, but I'll try to be really super brief. Just in addition to what has been said by Rainer and Marie on evidence-based, you see it in opinions that we also refer to sources. So our opinions really are like academic articles, and there was a discussion at some point in time, how do we go about it? So it's not only that we have to be absolutely sure, of course, there's lots of preparation that goes on beforehand. So we also select where we go to really get, see and talk to people on the ground, particularly if it's more politically sensitive, so that we are sure that we can say, we were there, we talked to the people, so don't tell us this is not happening. So the preparation, the whole process, but then also sharing of what we rely on. So if you say hate speech, we give examples of links to specific statements. But of course, we don't repeat those statements, which is another issue we sort of are careful about. In addition to inconsistency and continuity, two perhaps issues, internal readings in the Secretariat, and then readings of all experts on draft opinions before we meet for the plenary. so that everyone brings in not just their individual expertise, but also their experience in of being member of different working groups, so working on individual states, so that we can then bring in all these collective efforts in addition to what has been said already. And also when new members join, you know, it's always half of the committee changes every 2 years. So there is a little bit of an introductory meeting that we also try to help new colleagues, particularly those who are not returning, to sort of understand where to get the materials, how to interpret, what language to use. So we try to be as consistent as possible. And the guidelines. Of course, sometimes consistency doesn't mean you coming to the North Macedonian case. It means that sometimes you need to change your recommendation also. Like I think I understood the message that sometimes you forget in a way, like for the external work of some recommendations. Of course, it's frustrating if you keep on repeating the same messages. And of course, we will not drop a recommendation just for the sake of not being frustrated. But sometimes the situation is such that you simply need to take into account the broader context. If you recommended ratification of a certain document 25 years ago or 20 years ago, and in the meantime, no other state has ratified that particular treaty, then maybe we need to review if it's really fair and consistent to recommend a ratification of that particular document only for that state, or just because a similar recommendation was done 20 years ago. So that's a sort of like always kind of states often stick to state of affairs, and we should not do the same. Like we should be aware of the changes and challenges in societies, and then possibly also adjust our assessment in the recommendations. I'm not sure if I have time for much more. Maybe just one thing on this, and then let's talk during the break, and maybe also in the second panel when we very much look forward to hearing also other colleagues' assessments on the political and expertise kind of issues. Again, in addition to what already Rainer has said, sometimes you can say, and if you wish, you be critical, but in a way that is clever, so that you don't shoot yourself in the foot. This is what I meant, like that it's the place where you are critical when you do the assessment. And sometimes what Rainer was saying, you know, the draft resolution, if you know already in advance that the state doesn't accept one term, maybe it's a way of you not putting that term in the recommendation so that you also enable the Committee of Ministers to adopt a resolution and then have the assessment with all the problematic terms in the opinion itself. So this is, I think, the dilemma in a way. Yeah, but maybe, yeah. But maybe it's also, and this will be my last point, also how you kind of like what you suggest to the Committee of Ministers is also important. You will know that if you look at previous cycles, it's this distinction between immediate recommendations and further recommendations. And here a little bit of our own assessment, Elise, Emma, David, what sort of how we were assessing the 6th cycle opinions. Now what you will see in the 6th cycle is no longer the division between immediate and further recommendations, because this some states interpret it as these are the important ones and a few others. And of course, on top of it, whatever is there in the opinion, it's not really in the resolution. So for us, all recommendations are important, but of course, only some make it to the resolution. But now in the 6th cycle, we have opted for 10 priority recommendations. No further, no immediate, one package. So this is one way of how the advisory committee is reflecting on how to address perhaps the political challenges without compromising on the substance. And that's the key.
Thank you, dear panelists. We are getting the signals that it's time for a break, but before that, we will have 2 final comments, one by Dr. Basic and the final one by Dr. Korno. So please go ahead. I will just help you with the microphone.
I will speak in Serbian, and Prosto hvala Ljubici na pitanju oko zasnovanosti izveštaja na činjenicama i na podacima. Podsjetit ću samo da je jedna od ideja ove konferencije upravo bila da vidimo na koji način šta izazivaju preporuke i primjena konvencije. I čini mi se da su tu podaci izuzetno važni da bismo doneli preporuke koje su u korist manjina, u korist svih građana. I moje iskustvo i kao člana komiteta i nekoga ko se bavi podacima i prikupljanju etnički desegregiranih podataka, je tako da mi se čini da komitet ne raspolaže uvek sa tačnim podacima. Naprotiv, države su sklone da ulepšavaju stvari, a mi se oslanjamo na zaista sjajnu jedan tim ljudi koji je list predvodi i koji priprema većinu naših monitoringa savjetodavnog komiteta i koji su iz različitih izvora. Neki su dobri, neki su provereni, neki nisu i na kraju se to svede da se jednim delom oslanjamo na činjenice i na podatke, a dobrim delom na naše impresije i na naše iskustvo, što nije dobar metod. Mislim da se u ovakvim slučajevima moramo oslanjati isključivo na podatke i da bi trebali zajedno da tražimo rešenje, verovatno i sa Evropskom komisijom ili sa nekim drugim telima evropskim, koji bi ustanovili način na koji bi ne samo savjetodavni komitet, nego i druge tela koja se bave ljudskim pravima, raspolagali sa podacima na koji mogu sa više sigurnosti, sa više poverenja u svoje mišljenje da preporuče određene mere i aktivnosti. Hvala vam.
Yes, thank you. Just a final comment on my side, as I'm the executive secretary of the Framework Convention, and I'm the head of the team working on opinions. I think an important feature of the monitoring mechanism put in place by the FCNM is its collective nature, and this applies to the advisory committee, to the staff, because as Petra mentioned, indeed, we have internal readings. So one colleague would draft an opinion, and then there will be a discussion with the entire team on this opinion before it is shared with the working group. And there is also, the collective work of the advisory committee is also very important, and I think it helps also to mitigate, political opinions, subjectivities of individual members. And also at the level of the Committee of Ministers, it is also collective exercise. And this is also very important because some states will have, the temptation to deal on a bilateral level, their minority issue, the minority issues we may have. So I think it is important, to have also the Committee of Ministers as a collective body to address these issues, and I think this is the strength of the mechanism. And maybe a last word regarding the fact that indeed, opinions may change over time, that priorities may change, and I think it will also be kept in mind that this also reflects what minority representatives say to us. Because over time their priorities and concerns may change, and this will be reflected in the opinions of the advisory committee. And also what can be also very interesting is that in some cases you may have, if we speak about king states, we may have priority issues for king states, which is not at all reflected by the minority of that state. In the monitored states, they may have very different concerns, and this also has to be reflected in our opinions.
But indeed, we have several tools, as Marie mentioned. We have the source book, we have the glossary, we have also a UDoc database, which is used by the team. And I think this collective work, I mean, within the team is also very important. I mean, you have more experienced members of the team also coaching new ones, and you transmit this the experience and the expertise.
And the final comment on kin states by Professor.
Yeah, not a good term. Hence, we try to avoid it. Or like if we cannot, then we put it in inverted commas, as it was some neighboring state, interesting states, like all sorts of other reasons for various reasons that you mentioned.
Okay, so I'm sure that this discussion will continue over there in the hall, where we will have a short break. Thank you all for your valuable contributions, especially to our panelists. Thank you all once again. It was very interesting, and I think one last round of applause. And we will convene here at 12:20. 15 minutes, is that okay? Okay, thank you so much. So 12:20.